Good morning again, and welcome to our Google Hangout sessions today on this very rainy April day. Apparently we're expecting some more rain and maybe even some snow tonight. Can you believe it?
No, not at all. I'm not looking forward to that.
But don't worry, apparently it's getting better. And now that our forecast is done, let me introduce myself for those joining us for the first time. I'm Lior Samfiru of Samfiru to Market LLP. With me, as always, my colleague Lumi Punja.
Hi, good morning.
And again, for those that have not joined us before, first of all, welcome. And what we do here every couple of weeks, we do this session where we try to inform and advise with respect to an issue related to the workplace, to employment law. A lot of people call us with questions every single day at the office, and we try to pick these types of topics that hopefully would be relevant and important to as many people as possible, and discuss them. We're happy to take your questions right here live if you have them, and hopefully you'll learn something new today. The topic today is all about pregnancy and parental leave. It's a very important topic, and it's a topic that comes up daily, literally daily in our practice. Even though it is actually a straightforward topic, and we'll tell you about that today, it is one that a lot of employers get wrong, and a lot of employees end up having their rights not being followed, rights violated. There's the intersection there of human rights as well that applies to this topic. So we're going to cover all that. We're going to start off today by talking about who qualifies for pregnancy and parental leave, what that leave is, what does it actually mean, what rights do you have if you take the leave, do you have a right to your job, what happens if you lose your job, and if you do lose your job while on pregnancy and parental leave, what are you owed? So we're going to try to cover all these topics today. Again, we have limited time, so if there is a question that you have that we cannot get to today or that we have not covered, contact us after. We're happy to talk, happy to chat and answer any questions. Now, so let's start off with some basics. I'll start off here before I turn it over to Lumi. Let's discuss what is this pregnancy and parental leave, who gets it, and how long it is. Well, pregnancy and parental leave essentially are time off work. It's time off work that an employer is required to give employees, irrespective of the size of the company, irrespective of how busy the employer is, and irrespective of the position the employee holds in the organization. Now, pregnancy leave, as the name suggests, pregnancy leave is a leave that a woman that's pregnant, that's about to give birth can take. Now, to qualify for pregnancy leave, you would have had to have commenced the job at least 13 weeks before your due date. Now, that does not actually mean that you have to work for 13 weeks. It's just that you have started the job. You may have started the job 13 weeks before, and maybe you went on leave shortly after, or maybe you were on sick leave. You don't actually have to be actively employed for 13 weeks, but you would have had to have started the job. So if you start a job 5 weeks before your due date, you're actually not entitled to pregnancy leave. Now, pregnancy leave is 17 weeks. So it's a 17-week period of time that you have to take off work for your baby. Now, it can start 13 weeks. Sorry, I can actually start 17 weeks before your due date. So you can start the pregnancy leave at any time weeks before. In some situations, you can actually even start it even earlier than that if there's a medical reason and doctor support. But usually you can start the pregnancy leave component at any time up to 17 weeks before your due date. Now, all you need to do is give your employer notice, and at that point, the employer has to allow you the time off. Now, for mothers that have taken those 17 weeks, they can take then an additional 35 weeks parental leave for a total of 52 weeks. That's why we get the year off component. So you can take up to another 35 weeks. So if your first day off work is the date that you give birth, that you can be at home with your baby for a full year in the case of a birth mother. So you have 17 weeks pregnancy leave, 35-week parental leave that you can take, and that means that for that 52 weeks combined, you have job protection, and Lumi will elaborate more as to what that means. Now, of course, it's not just birth mothers that are allowed to take time off if they're having a baby. So birth fathers are allowed to take time off, as well as other parents. For example, if you've adopted a child, you can take time off. So for anyone that's not a birth mother, so all other parents can take up to 37 weeks of parental leave. So 37 weeks, let's call it right around 8 months or so of parental leave. And again, that's job protected leave. A father and a mother can be off at the same time. There's no issue there. And all that's required is to give notice to the employer with respect to when the date is. Strictly speaking, you're supposed to give 2 weeks notice. We can tell you in our experience that that 2 weeks requirement is not strictly followed, and you do not lose your right to take a leave if you don't give that notice. With respect to coming back to work, so we've talked about a birth mother having up to 52 weeks, 17 and 35, all other parents having 37 weeks. You're supposed to, again, give 2 weeks notice to your employer of your return to work date. And again, it's not something that's strictly followed, but you are expected to give notice to your employer. In no circumstances can failure to give notice cancel your leave in any way. It's a requirement, but it's essentially a requirement without teeth. So all you have to do is understand that you have that leave, and that means that your employer has to give you that time off. One thing to also be important, while you're off on this leave, your seniority carries through. So it counts towards your seniority. So you may have had 3 leaves over the past 6 years, and you've been off for 3 years. Well, those 3 years count towards your seniority. So you're now a 6-year employee, not a 3-year employee, and that's important. A lot of employers, for reasons that are unknown and they're illegal, don't count the leave as part of the seniority. So remember, it doesn't matter how many weeks, months, years you were actively employed. If you've been on a pregnancy or parental leave, that time counts towards your seniority. Now, you also qualify for benefits. An employer has to continue your benefit coverage while you're on a pregnancy or parental leave. That's very different than other leaves. If you're on a medical leave, for example, your employer does not have to continue your benefit coverage, health, dental, etc. But with respect to pregnancy and parental leave, yes, you absolutely have to have those benefits if you, of course, had them otherwise. You would qualify in most cases for employment insurance, for EI, while you're on a leave. An employer does not have to pay you. Of course, your employer can top you up. EI has its own rules in terms of qualifying. They're very similar to the other rules that we've mentioned, but they are different. But as long as you understand that you have 17, 35 weeks, you have to have your job ready for you when you come back, you have to have your benefits covered, and your seniority continues, those are the key components of a pregnancy and parental leave. Now, Lumi will elaborate a bit more in terms of this concept of job protection and what does it mean, and what are the employee's rights and the employer's rights.
I would just like to add on the benefits point that, for example, if the employer pays 100% of the premiums, obviously that right. has to continue. And if there's an arrangement where the employee is responsible for a portion of the premiums, then the employee is responsible for contributing that portion throughout the time off, and the benefits will continue.
Right.
Now, with respect to job protection during pregnancy and parental leave, and just I will say that throughout our discussion today, I may use the word maternity leave or mat leave, which would encompass pregnancy and parental leave. The technical terms are pregnancy and parental leave, but we sometimes use maternity leave in an informal way. So the main thing to keep in mind for employees and employers is that pregnant employees are entitled to be reasonably accommodated in the workplace if the circumstances warrant it. So, for example, many employees, pregnant employees, ask for flexible hours because of morning sickness or because the commute to work as a result of the pregnancy is more difficult or lengthier. So in those cases, the employee should seek reasonable accommodation in the form of flexible hour, for example. Also, medical appointments, time off for medical appointments is a common request by pregnant employees, and obviously that should be accommodated. What employers should stay away from is making assumptions about the employees wishing to work fewer hours or wishing a reduced workload. Employers shouldn't make assumptions about what the employees I guess, desires, preferences, priorities are. But if the employee approaches the employer with requests that are supported, for example, with a medical note, or it was just the common sense requests such as flexible hours or time off for medical appointments, those should be seriously considered and granted in virtually all of the cases. At the end of pregnancy or parental leave, you as an employee should get your original position back. And so an employer cannot change your job title and then say that the position is no longer available to you. You're entitled, if your key duties and responsibility have remained, then you're entitled to, I guess, being reinstated in that original job. If the original job was legitimately modified in your absence, then the employer should put you in a comparable position, offer you a comparable position. What employers shouldn't do, and it actually happens quite often, when they hire a replacement for someone who goes on pregnancy and parental leave, they may like the replacement person more, and so in many cases they let go the person who took time off and keep the replacement. That should not be done. And employees who find themselves replaced at the end of their time off should contact a lawyer. You definitely need legal advice in those circumstances. There are serious repercussions for employers who don't follow the reasonable accommodation requirements. Those who again take liberties with the original position or comparable position again requirements, and employees have quite extensive rights on this front. Now, in many cases, changes in the workplace happen in somebody's absence. It's legitimate for an employer to want to make changes for business reasons, for efficiency, and so in those, but that has to be properly supported by the facts. It can be just arbitrary changes or changes that are clearly targeted at making it more difficult for the employee to come back.
Now, here's something, probably the key as far as we're concerned, certainly when it comes to the issues that we're dealing with, and that is the fact that an employee, under no circumstances, father or mother, can be penalized in any way for taking a parental leave, for being on a parental leave or pregnancy leave, and in no way. And the law comes down very hard on employers that do that. And let me give you an example recently of a case that I had. I was speaking with a young lady, worked for a company for 3 years, was doing really well, been very successful, and then announced to her employer that she's going to be taking pregnancy and parental leave, and she's going to be gone the full year. She told them that several months before she was actually going to take the leave. Well, what happened there, and almost immediately, within a few days, all of a sudden, nothing she could do was right. She started getting bad performance review, criticism. She was threatened with her job security. All of a sudden, everything she did was that she did before when it was good. Now all of a sudden it was wrong. Well, and then she called me frustrated and very upset. And it was so clear that what this employer is doing is essentially penalizing her, maybe trying to drive her away because she's going to take this pregnancy leave. An employee doesn't become a terrible employee overnight. That's nonsense. And in this case, it was very, very clear that this employer is either trying to find a reason to let her go so they don't have to give her the leave, or trying to get her to quit. That's wrong. And it's not just wrong morally and ethically, which of course it is, it's wrong legally. It would be a violation of both the Employment Standards Act and the Human Rights Code. Under the Employment Standards Act, if you penalize an employee for taking a leave of absence, a pregnancy or parental leave of absence, that's what we call a reprisal. If someone tries to enforce their rights, and because of that, then they get fired, they get penalized, they get disciplined, they get warned, mistreated, anything at all, that's a reprisal. Same thing applies if you're on a leave and you lose your job because you're on a leave. and your employer does what Lumi says you shouldn't be doing. Your employer says, well, we're going to keep your replacement and we're going to let you go. Again, that's wrong. Not only at that point would it be, again, a violation of the Employment Standards Act, it would also be a violation of the Human Rights Code. Completely and utterly illegal. You know, I have a line that I use, hopefully I don't insult anyone, but that line is, you don't mess with mama. You simply don't. It's very important. So I've had callers on my show, I've had employers call me saying, I have this employee, she's coming back from mat leave, we want to let her go, how do we do it? And my answer is, you don't do it. You absolutely don't, because then you're going to be in legal hot water. So it's extremely important. Now, I've seen also some employers legitimately let someone go, except they did it wrong. Let me give you an example. I had several clients over the years where they received a letter from their employer saying, we know you're still going to be on mat leave for 6 months, but we want to let you know we don't have a job for you anymore. We lost a client, so we're letting you go. Now, let's assume for a second that this was legitimate, that the employer legitimately didn't have a job. But let's think about this. The legal obligation of the employer is to take the employee back at the end of the leave. The employer can't assess its ability to meet this obligation until the end of the leave. So it's possible that now, 6 months away, we don't have a job for the employee. But 6 months from now, we may have a job. We may have 5 jobs. We may be desperate for this employee. So an employer can't decide early on that they're not going to have a job for the employee in the future. It's very, very important. Now, Lumi's mentioned, and I'll reiterate, that an employer cannot, under any circumstances, let a parent go because they took a leave. Now, in some situations, if the termination has nothing at all to do with the fact that the person took a leave, it's okay, it's legal. I'll give you an example. If an employer shut down the department and let go everyone in the department, including the person that's on a mat leave, well, that's okay legally, because they're not obviously being picked on. They're not picking on the employee because they're on the leave. But if the only person in the department that was let go is the mother that was on a maternity leave, well, guess what? That is illegal. At that point, it makes it very clear that the only reason the person lost their job was because they were on maternity leave, and that cannot happen. It still shocks me, because everything I've just said now should be common sense, but every day we get calls, both of us and the other lawyers at our firm, from parents that have been let go while they're on mat leave, just before they were about to take mat leave. And I shake my head in disbelief that employers still think they can get away with that. They can't, they shouldn't, and the law is very, very clear. Now, if you're in one of those unfortunate situations that you lost your job while you're on a parental or pregnancy leave, you have entitlements, and those entitlements may be enhanced. So with that in mind, I'll turn it over to Lumi to talk about what those entitlements are.
And yeah, I will say that you actually mentioned this earlier, but I think it's worth reiterating that if somebody gets notice in the middle, receives a termination letter in the middle of their pregnancy or parental leave, that notice is not effective until the end of the, I guess, 52 weeks that the time off would be for. So even if there are, I guess, employers who think that they mean well by giving, again, advance notice and quote unquote allow their former employees to plan ahead, right? But that's the law doesn't recognize that, and in many cases the parents don't see that as well, like as a good thing for them. And so there is case law that says that notice of termination doesn't become effective until the end of the pregnancy and parental leave. So that's an important point to keep in mind for employers and employees. The other thing that should be front and center in a discussion on this topic is that pregnant employees or employees who lost their job in the middle of their time off or shortly after coming back to work from a pregnancy and parental leave have enhanced termination entitlements. The courts recognize the practical difficulties of replacing a job, replacing your income while pregnant, or while caring for a young child. And so in general, cases support lengthier notice periods for employees who are in these circumstances, again, who find themselves unemployed while pregnant or while caring for a young child. And there's logic behind it, and it's just, again, in a way, common sense, but employers sometimes forget that and expose themselves to quite a bit of liability when they terminate, for example, a short service person, a young person, but because of the child caring responsibilities, and because of the the actual reluctance in the marketplace of employers to hire someone who is pregnant, that there are enhanced termination entitlements available to terminated employees.
Yeah. So at the end of the day, if you lost your job when you're pregnant, while you're on maternity leave, when you come back from maternity leave, not only do you get severance, we always know that, but you probably and most likely get even more severance than you would in other situations, and that's far and apart from any human rights entitlements that you may have as well. So that's why I said there's a lot of liability for employers that get these things wrong. A lot of liability, a lot of exposure. This is one area of employment law where the law is clear, the law is unambiguous. There's not a lot of wiggle room, and the law is quite extensive in protecting employees. So keep in mind, you have a right to time off work. Your employer has to give you your job back, same job, same pay. Can't decide they like your replacement better. Can't let you go or penalize you because you're taking a leave of absence, and of course can't decide months before you're ready to come back that you don't have a job. And if you do lose your job, if it's in any way, shape, or form related to the fact that you were going to or you did take a maternity leave or parental leave, pregnancy leave, that's illegal. There's human rights issues there. You have to get legal advice, and we're always happy to talk, answer questions. With that in mind, hopefully we've informed and educated a bit on this topic. There's a lot more that can be said about it.
I would just like to add one point. So also, not only if you're terminated, but if your hours get reduced, right, or your pay gets reduced, again, in the middle of a pregnancy, or you get a letter in the middle of your leave that, again, your hours or your pay has been reduced in your absence, you don't have to accept the changes, and you may have a very solid case for a constructive dismissal. So those are scenarios that are covered by the law, and we're happy to help you assess your entitlements if that happens to you.
So don't ever be shy or think that you don't have recourse if you find yourself in a situation where your job changed, your job was lost, you were penalized in any way. Give us a call. Always happy to talk. You can visit our website at stlawyers.ca for more information. And for us, that's what we had to say this morning. Look forward to seeing you again in 2 weeks, and hopefully the weather's going to be much better.
Have a good rest of the week.
Take care.